This is Colin O'Keefe here for LXBN TV. In a decision that was very controversial at the time but was lost in the conversation of other decisions, including same-sex marriage, the Supreme Court last month struck down a key provision of the Voting Rights Act. Joining me now to explain why that happened and what's next for the Voting Rights Act is Christopher Rissetto. He's a partner with Reed Smith in Washington, D.C., and author on the firm's Global Regulatory Enforcement Law blog. Chris, there have been times when the Supreme Court has been very reluctant to go over the head of Congress, but this is not one of those times. Why did the Supreme Court decide that this is the place for state rights and to overrule Congress's previous unanimous vote on the Voting Rights Act?
Well, thank you, Colin. Certainly there's always a danger in conjecturing the meaning of the Supreme Court, but here there's really four things, I think, which help to explain the Shelby County decision. First is, this was not really the first time the Supreme Court had ventured into these analytical waters. 4 years ago, in the Northwest Austin water management decision case, the court warned, in effect, that it was looking very seriously at changes in the South, demographic changes, voting changes, and the like. And raised the issue of having to justify the needs for really not trampling on, but seriously interfering with constitutional structure between the states and federal government. So number one, there was already a warning before. Secondly, the second point is Chief Justice Roberts in the past had shown in his both writings, going back to his early days in the Justice Department, that he saw kind of racial gerrymandering as a sordid business, something that is to be avoided, again, giving due respect to the state and federal tensions, excuse me, cooperations in the Constitution. So you had a prior warning, you had warning to Congress that things had to kind of keep up with the times, and you had the Chief Justice's own considerations that kind of suggested they were looking for the right set of facts, the right case. Thirdly, concerns with federalism and the 10th Amendment. I think it's fair to say that the court was concerned with the rubber stamping, my words, but the considerations that Congress perhaps was not giving to these demographic changes as they move through these important reviews of the Voting Rights Act and the renewals of the Voting Rights Act. Remember, the Voting Rights Act was extended only for limited periods of time, and ultimate extensions went up to, they moved from a period of 5 years to 66 years. So the net effect of this is something that had gotten out of hand, again, considering the careful tailoring that was necessary to avoid interfering with concepts of federalism and the reserve powers of the states in the Constitution of the states. Lastly, kind of the tradition of equal sovereignty, if you will. States are supposed to be treated equally. It's more of a doctrine, not a particular constitutional requirement. But here you had 9 states and certain counties that were signaled out for very disparate treatment, different from the other states. And that weighed on the court, certainly the majority's mind. And I think that was something that was of great concern to the Chief Justice particularly. And again, called forth the need for Congress to step up and show that the careful tailoring that they were doing is what was needed to kind of go beyond or to not give proper deference to the separation of powers, to states' rights, and the like. So I think you had a warning, there was consideration of wanting to be sure that there was currency and that Congress was really doing its job. So I think the court said, we warned you before, and Shelby County is really what is our final word on this. You, Congress, have to go back to work.
I see. So speaking to that, what is ahead? Congress previously gave this a quick stamp of approval, but as you mentioned in your post and then here, that's likely not the forecast this time around. What do you think will happen with this? How will Congress handle the Voting Rights Act in the near future?
Well, you're certainly correct that there's not going to be a rollover here by Congress. Let's take just a quick step back. 2006, when the Voting Rights Act extension was passed, 390 members of the House voted for it. 98 members of the Senate voted for it. George W. Bush signed the bill. Wide bipartisan support, well received, well respected legislation. Now the court has said that two key concepts have to be observed by Congress in going forward. One is you have to justify a statute's current burdens by current needs, currency. We have constitutional, states' rights, federal rights. This has to be, Congress has to look at this. And then you have to, again, because of the disparate geographical concerns here, you have to have the problem and the geography tailored together. In short, things have become political, very political. You have vested rights that have developed over the last 30, 40 years. And there's a wide disparate view as to what this really meant, what the Supreme Court really was trying to say in its case. John Lewis, for example, who led, Congressman Lewis, who led the 1965 Selma Peace March, said that this was a dagger, that this decision of the Supreme Court was a dagger at the heart of the Voting Rights Act. Eric Cantor, who's the House Majority Leader, said, let's put politics aside, let's find a responsible path forward. Right away, you can see the difference between a Republican leadership view and a Democratic leadership view. One sees restatement or bringing back the Voting Rights Act as it was as key. Another says, let's find a better way. Chuck Schumer, number 3 guy in the Senate, said that the key answer is to get Republicans out of positions of power. That interjects bipartisan aspects of it again. John Cornyn said, let's give this the old college try. One minority advocate said, let's have a constitutional amendment. So you have a wide variety of people looking to do a wide variety of things. 2 key things are important. One is hearings were immediately scheduled tomorrow. The Senate, July 17th, is going to have a full committee hearing before the Senate Judiciary Committee. John Lewis will be on panel 1, as will James Sensenbrenner, who was chairing of the House Judiciary Committee when the first Voting Rights Act was extended in 1965. The next day, July 18th, the House is going to have a hearing. Big difference. The House's hearing is going to be not a full committee. It's going to be before the Constitutional and Civil Rights Subcommittee, chaired by Trent Franks, a Republican from Arizona, one of the 33 that voted against the 2006 voting right extension. So you can see you have some partisan differences. You have vested rights that are moving together. And the background to this is the marching orders that I think the Supreme Court has tried to give here about tailoring the constitutional considerations and tailoring the need for this. It doesn't matter to the Supreme Court what really happened, what good things happened. Unlike the dissent in the opinion that said, well, why should we stop this? It's done wonderful things. Supreme Court said yes, but the risk and the cost are too high. So they say you have to step back and prove it. And that proving it, given a Congress now that can't agree on much of anything, is going to be very difficult. So I don't see something happen immediately. There will be a lot of, I'll say, political activity, a lot of media contacts, much public debate. Not likely that there will be an immediate change to this. Down the road, there may be, but it's really entered now the realm of the political versus a continuation of what's happened before.
Absolutely. This is going to be a very interesting story to watch. I think that's where a lot of the discourse stems from, is the fact that Congress has been having a very difficult time accomplishing things as of late, and this stands to be potentially a very politically charged subject. Once again, that was Christopher Rissetto of Reed Smith. For more of his analysis on this ruling, be sure to visit globalregulatory-enforcement-lawblog.com. And if you're not already watching us here on LXBN, be sure to visit LXBN.com, where we have hundreds more video interviews on LXBN TV. And we also have curated commentary from the LexBlog Network's more than 8,000 members, many of whom have been doing an excellent job as of late commenting on the Supreme Court. Thanks for joining me today, Chris.
Thank you very much, Colin.